Aloha, everyone. My name is Michael Palmieri. I'm the Executive Director of Creative Lab Hawaii. On behalf of Georgia Skinner, Chief Officer of the State of Hawaii DVET Creative Industries Division and the founder of Creative Lab Hawaii, mahalo for participating in our Zoom webinar on collaborations agreements co-sponsored by California Lawyers for the Arts. In a moment, I will introduce our presenter, though first I wanted to share a little bit about our webinar. Our presentation will last approximately 40 to 45 minutes, which will leave us 10 to 15 minutes for questions from our viewers. If you're interested in asking a question, please do so as the discussion unfolds. We will choose these questions from the queue when we start that portion of the program and answer as many as time allows. As a reminder, the series of legal clinics presented this month are for informational purposes only. If you require specific legal advice, we recommend you consult an attorney. Now, let me introduce you to our presenter, Tifanie Acosta. Tifanie Acosta is a partner at Entertainment Law Partners. She represents many corporate clients and entrepreneurs, as well as individual actors, writers, directors, musicians, agents, PR agencies, managers, and producers in the corporate business and entertainment industry. She most recently also became business affairs head for a new effort called Mogul. So if you want to find out more about it, feel free to Google her. And the name of that company is Mogul, M-O-G-U-L. She began her career as head of business and corporate affairs for the prestigious personal management company of Royal and Associates in Beverly Hills, California, representing entertainment talent as well as corporate interest in the industry. From Royal, Tifanie was recruited by TFN, the football network, as general counsel and corporate secretary to manage corporate governance, talent negotiations, development and acquisitions of programming, including options, live and taped sporting events, documentaries, home video DVD distributions, news shows, reality, internet content development, and syndication at a publicly traded company. Tifanie has maintained her own practice representing high-profile personalities, talent, production companies, and entities. Tifanie is a certified mediator, writes for InsideFilm.com, has lectured at Southern Law and Louisiana State University, and serves on panels discussing various issues in the entertainment industry. She is also a voting member of the Academy of Television Arts and Sciences, the home of the Emmys. Tifanie, take it away.
Well, hello, everybody. Thank you, Michael, for that introduction. So today, I'm basically speaking about collaboration agreements. Collaboration agreements is a big word. So I guess we can start with what kind of things that means, like collaboration. In general, in our business, when you collaborate with somebody, it could be on varying levels, anywhere from just getting an idea and helping somebody out to a full-fledged formal and legal partnership. What I'm discussing today is basically the three most common general ways that you can collaborate with somebody in a certain function that you're serving. This really focuses on things like producing, writing, potentially doing business together from your each of your expertises, and then moving on to, how does that look like in the form of being legal or formal in that relationship? So with that, what I always say when people call me for the first time to tell me that they're interested into entering into a formal relationship with somebody, I always ask them that to consider not only the good things that's going on with that potential collaboration, but also what does it look like in a way that could potentially break up the partnership or break up the collaboration that you want to do. So as I discuss these three different ways that you can collaborate, what I always have when I go through these with my clients is to really understand what I call the divorce, what it means also going forward if you were to divorce. So when we're planning a partnership or a collaboration, I always look at what the good things are, but potentially what the downsides are and how to really address that at the forefront of the relationship so you can manage expectations and really understand what everybody wants out of the deal and what potentially would need to happen if the deal were to terminate and the parties were to basically separate from one another. So with that, I think we'll start with, for you producers out there, the co-production agreement. What is a co-production agreement? It's a very broad understanding of what is a co-production. Co-production could be anything from two producers aligning interests to do one project together and help each other with one single project. It could also mean you partnering with somebody in a completely different country where you are able to take advantage of certain opportunities that that person in the foreign territory can give to you. Say, for example, here, when you're in Hawaii, there's these great tax credits, and maybe you would like to partner with somebody who's actually on the ground in Hawaii and get from them things like location scouting or their office space or their production studios. So each party is bringing something to the table that will help elevate and move forward the project that you both want to work on. So co-production agreements can vary in different ways, but really the main theme of what that is for everybody to come together to decide how to get this project made, how to get a movie made, how to get a television series made, whatever the project is. That is kind of like the driving force of you wanting to form this co-production with somebody else. So why do you need it formal? Why can't I just, for example, call my friend that lives in Hawaii and say, hey, let's do this together. If we get it together, that's cool. If not, then we can just move our separate ways. The reason that it's really needed to be in a formal way is it helps to manage what each responsibility of the parties are. It lays out not only the expectations of each side, but it also lays out the role, like what's your job and what's my job. I know we're both producers, but as we know in our business, being a producer means several different hats and several different jobs at any given time. So when I usually start out with my discussions about what to do with a co-production, I ask both sides, well, what are you doing and what are you doing? And we lay out a list of all the things that each party is going to do. Now, on many occasions, what happens is that there's things that are missing. For example, say that one producer is going to get all the talent and one producer is going to get all the locations. Well, that's great. But my next question is, well, who's going to get the money? Or who's going to get the director? Who has the script? Who has rights to the script? So with all of these things, as you enter into a co-production agreement, there are certain things that maybe both sides can't do. And you may need to have an awareness that we'll have to have some help later on down the road, but these things that we both decide to do together will actually be the foundational formation of what we want to do as a partnership moving forward. Going back to the questions about, well, what happens then if there are gaps in what each side wants to do? What does that mean for the project going forward? What if those gaps that I had brought up don't come to fruition? Does the co-production agreement end? Do you decide to potentially bring on an additional person into the co-production relationship? And all of those kinds of nuances that you would need to figure out as we move forward. The co-production agreement is kind of like a living document. It's a roadway or a map into what the collaboration is going to look like as producers. Eventually, it will need to either expand or it will need to move into the next phase, meaning that you're actually getting to the place of getting the movie into production. And then we discuss how that is going to work as producers when you're co-producing something together as a partnership, and how that looks going forward when you're finally at the point of production of the specific project. So when you're doing all of this, there's all conversation and everybody's excited, but another question is on the list is, well, when do I do it? Like, what happens when I'm excited and my co-producer is excited and we want to move forward? Do we really need to put it in writing, or do we just kind of wait out and see how everything is going and then do it? My suggestion is that you really need to do it at the point when there is a significant and material amount of time that each person is going to contribute to the project. And that is when you really need to be specific enough that you're going to be sitting down and serious with a lawyer to really lay out the entire co-production agreement. Generally, a co-production agreement, when you do that, it could be as simple as a 4 to 5 page agreement. And I've seen very, very large ones, 30 to 40 pages, because it lays out all of the roles, all of the compensation, what the termination language would look like, and what the expectation of the parties are. With that, I think that with co-production agreements and being a producer in specific, if you're partnering with somebody, the number one question I have after we all have laid out everybody's roles and what everybody's doing is, how is the project going to sit? And what I mean by that is, what does it mean when I come as a producer and I have the script, but my co-producer has the talent, right? So all of those pieces are super valuable to bring to the partnership. But the question is that who's going to control these rights until you get to the point where you're available to be comfortable to proceed with the production of the film? Usually what happens is, with regard to the rights of a project, it's all within the scope of what the producer has worked on in order to get the rights to it. It could be as simple as, I'm the producer and it's based on my, on my life, right? And I'm writing the script. So I come with not only being the producer, but I'm also the writer because it's based on my life. So I kind of ride in the seat of producer, writer, and I can come along with all of that package. My partner, could potentially have a really big talent who's their best friend, for example, and those two things are super valuable to the package, which is why there's an incentive for you to join forces and come together as a co-producer on this specific project. Generally, also, what I always say too is that when you are coming with certain rights to projects and you're entering into a co-production, I never generally recommend that the rights get involved with the actual co-production agreement. I recommend that you always wait until we figure out what we're going to do with the project itself and whether the project itself is going to need its own formal documentation, meaning, are we going to form a company just for the movie, and how do those rights specifically lie for there? But as a producer, you're bringing valuable things to the table, and that is why one of the things and items that we would need to address in the co-production agreement. Going through some of the drawbacks of a co-production agreement and the benefits, going back to my divorce initially when I spoke here at the beginning, the drawbacks to a co-production agreement is that it's formal. So you can point to the document and hold somebody to what they're supposed to be doing. So if my co-producer is supposed to have found a beach in Hawaii for a location and they never did that, that is a concern to me, because that's holding up a potential acceleration of what we need to get the project going and scouted and having locations laid out. If there's a consistent failure for one of the parties in the agreement to deliver what they said that they're going to do. For example, I had a co-production agreement where there was 4 people in it together, and one of the parties wasn't able to deliver one of the talent that they said they were going to deliver. So the 3 of the other existing partners were very concerned about them having had done all of the work, and this 4th person was not really kind of staying up to par with the expectations that they were supposed to deliver. And then there happened to be a conversation about, what do we do with that 4th person? Do we ask them to remove themselves from the partnership? Do we ask them to try and deliver a replacement talent? Or do we revise the agreement with new requirements or expectations so that the partnership can still move forward, but the other three partners are not feeling like the other one is not contributing or not holding their weight. So a lot of frustrations that I see with these co-production agreements is with regard to holding the expectations and having a roadmap of what the duties and responsibilities of each of the people are going to be. So I'd say that that's one of the number one drawbacks to entering into such a formal agreement. However, that's also a plus because you have something to actually point to that would give you the ability to have a justification for you're not producing or you're not doing what you said you were going to do. Let's have a discussion. I don't feel like you're delivering at certain points of expectation. Shall we amend this? Do we agree to dissolve it? Or is it something that we need to put you in a different capacity, either dropping down to an associate producer or a consultant and removing you from the active pursuit of producing a specific project? Obviously, the benefits outweigh the drawbacks when you're ready to actually move into these formal agreements. It also gives you a roadmap on what your producer agreement is going to look like eventually. We usually use co-production agreements as the basis to negotiate the ultimate producer deals with the entity that ends up producing the film. Such things as we'll work out credits already, we'll work out placement of credits, compensation, expectations, who is going to do what, who's going to be physically producing it, who's going to be packaging it, who's going to be, financing it, arranging for financing. So again, as we know, producers wear several different hats, and with all of these different responsibilities, the roadmap of the co-production agreement really allows us to move forward with the idea of how that is going to then translate to the ultimate producer's agreement. So it's a moving document. It really lives on its own. And if we plan it right, it's a really great way to avoid conflict. And it's a really great way to facilitate communication, especially if a lawyer does it. That if there is a misunderstanding or somebody saying, no, that's not what that means, I did that, you can always get an advisor on the phone and help you run through what the expectations were in the agreement and even amend it or move it around or get some type of alternative dispute resolution as the people move forward. Now, I have seen on several occasions it work fine. Very high level producers, they have their own production companies. They know what they're doing, and they enter into this co-production agreement because of the relative talents of each one. And that then leads to all of the pieces being put together on a collective basis to move forward a project. I've worked on very high level projects where one was a financier, one was a local production company, and one was a very high reputable producer. So all of those pieces were put together because the reputable producer was able to get the talent and all of the rights to all the scripts and the projects. Obviously the financier, always our best friend, right? Can always bring in the financing and able to finance the project. And then you have on the ground person. If we're filming again in Hawaii, we have that local person that knows all the rules, all the tax credits, where to film, who to hire, all of those different things. So with all of those different talents, that co-production agreement can be seemingly moved into the ultimate production of a project. So with that, I will answer any questions at the end of that, at the end of this webinar on co-productions. But with all of that said, I will now move on to another interesting collaboration agreement, which is always my favorite, and that has to do with writing. That's the creative part of this. So what happens when you are writing something, right? What is an author, and how do people collaborate? There are so many various ways that you can collaborate on your project. If you're writing a treatment, all the way up to a full-fledged script or television series. the key is to really understand how you guys are working together. Now, ultimately, if you're working by yourself, it could be fine, because then you don't have to worry about sharing your profits or your credit or anything else. But very rarely do you see a writer completely write from beginning to end without some type of input, involvement, collaboration, or material that's based on somebody else's written material. So author collaborations are very interesting. They are like children. They're all different. But what I can say is that when you're an author and I call you the baker. And the baker is kind of the person that starts with all the ingredients. And you have your sugar and your flour and your cocoa powder and your cinnamon or whatever else you want to put. And you start putting the items together to start to bake a cake. But there is going to be people that decide, who come into the kitchen that decide, you know what tastes a little bit better if you put a little mint in it, right? So it's like a mint cake. That's kind of different and unique. And you're like, yes, I'll put some mint in it. Then somebody else comes by and says, well, you should bake it at 350, not 400, because it'll stay moist. And you're like, okay, I'll do that. And then you get the cake out and somebody comes and says, I have the best frosting. Let me frost it for you. So with all of these different elements, you're actually collaborating already without even knowing it, not even knowing it in a formal way. But with all of these different elements and ingredients as an author, you're getting from all of these different people, different ingredients to help you build your project. With all of that, you have to be cognizant about, how do I give credit, or how do I involve all of those people potentially in my project? So the question is how much do you do on your own, and then on a formal kind of sense of understanding is, who do I want to work with, and what ingredients should I actually put in my cake, and are they material enough to have changed my original concept? So with all of those ingredients, then going back to the legal aspect of it is, then what do you do? So I always, when I have my clients call me and say, we're going to write a script together, or I have a script and, my friend has helped me develop some characters, or my friend has helped me develop some scenes, and, it's really kind of changed the scope of the project. What do I do? My very first thing is, tell me exactly what this person did. And we lay out everything that person did. And my second question is that it, or do you feel like you're going to continue the relationship? Do you feel like this is an ongoing relationship where, as the project develops, you're going to need that other person to help you with all of the changes and edits and the growth of the project as it gets written? Most of the time when there's people who are materially contributing to your project, that's when I do advise to enter into a co-author relationship or a co-writing agreement. In that, it lays out, again, the expectations of each party and what they need to do and when. In a writer agreement, one of the main things to really find out is what is the timeline here? Or is this something where you guys have been hired and you need to deliver a script in 2 weeks? Or is it one of those things where it's kind of your passion project and you guys really want to pursue it on an ongoing basis, but there's more of a loosey kind of outside date that you kind of want to then deliver the project? Why that is so important is that you want to be able to depend on that person that you're working with to deliver what you're working on, because it's your passion, it's your project, but ultimately it's something that you want to make money off of. So the quicker you can get it done and sold, which means obviously you get to move on to your next project and get that worked on. So co-writing agreements is a scope of a collaboration in a creative way. So other than for the co-production agreement, which is very specifically laid out for duties, in an author co-writing relationship, it's based on creative expectations. Are you going to contribute to the treatment? Are you going to help me write the script? What about a polish of the script? Are you going to be involved with, everything going forward? What happens if they don't like what you contributed, right? How are we going to get out of this relationship? Or how does it move for the scope of the expectations of the responsibilities for the person that potentially the producer did not like the contributions of your partner? So again, it's a living document, but it's on a more creative basis. So what you'll see generally in a co-writing agreement is who really came up with the idea, who owns the underlying material. What I mean by the underlying material is it based on a book? Is it based on somebody's life? Is it based on your neighbor's story? Is it based on an article that you read in the Wall Street Journal? That really is important to figure out how it's got based on and who came up with that initial formation of the concept for the project. Then from there, we can tee it up from there about, okay, so writer A had the idea and it was based on an article from the Wall Street Journal. Great. From there, is the writer B going to write the treatment? Are you going to co-write the treatment together? What's the timeline of that? Then from there, we could even go into things like, okay, if you both like the treatment, we can move on to a long outline, for example. If neither of you like the treatment, then you write another treatment. If one person likes the treatment and another one doesn't like the treatment, is that an opportunity for you to each go your own way? Or is it an opportunity for one to make the ultimate decision to move on or not? So again, these are very specific questions that as a creative person, you really don't want to think of. You just want to write, but really it protects everybody in that whatever the creative contribution is being made to the partnership, that it actually goes through in such a way that you have a function and a mechanism in order to help flow the relationship along, or a way to get out of it, which again, it goes back to my divorce recommendation, is thinking about what that means as far as a termination of agreement if the expectations of neither of the parties is really working out. Another big thing too with co-writing agreements is how is the project being formed? Because if you have more than one writer on a project, you have to understand the ownership aspects of that project for each person. As a general example, if there's 4 people that have come together and they're writing a series on vampires, and one person gives the character development, another person gives like the scenery and the backstory, another person kind of develops a love relationship between 2 of the characters, and the other one develops the whole arc. Those are 4 very big aspects of how a project gets written. It's very important to the creative process to get all of those elements provided. The issue becomes then all 4 people from a legal basis now will own the project because they have all contributed to one project. And that what's called chain of title. And I'm not going to go to chain of title today. That's a whole different subject matter. But what's important with regard to the collaboration agreements is even as you have an agreement with all 4 in this scenario and it's not working out, there's still what's called the ownership of the chain of title. So at such point where everybody's contributing, so long as the contributions are being added and going along and you're using them, then all 4, in my scenario of the vampire collaboration, would move forward. And if all of them are being used together as a group to move the project to the next stage, then each person would basically own 25% of the project. Now, for example, let's say that you didn't like any of the characters in the vampire film. You wanted to do an entire new cast, and the person that developed the original 4 people, you didn't want anymore. Like it wasn't something that you worked out. Well, because you're not using what that person developed, you would not have to worry about not having that person own the project anymore, because you're not using their intellectual property, their character contributions to the project, because you took that out. It's like kind of cutting out that piece of the cake that that person had contributed to, and bake a new one with the ingredients, without the ingredients that the fourth person who did the characters would have contributed to. So again, going back to the moving, living document, when you do these co-author relationships, you should really have in your mind the expectation of what it's going to take to move forward. And if the parts that that person has actually contributed to aren't working, then how you to move that project away from that particular person that didn't work out, and moving the project away and on its own for either a different collaboration or just with you as the sole author of the project. So with that, we will go into next. Again, I'll answer questions on also the co-writing agreement at the end here. But the third and final one is the most, I would say, business formal relationship that you can enter into, which is called a joint venture. A joint venture is a collaboration between two established companies or persons. It is very important to know that a joint venture can create a formal legal partnership on its own as well, with some specific functions that you have to do legally. I won't go into that, but a joint venture is basically saying our businesses are going to do a business together. Our respective sides have decided that we're going to take our own contributions and make its own business formally with a joint venture agreement. I would say one of the main examples of what I would say a joint venture agreement would be like a slate. If two parties have a couple of projects that they have in line that they want to produce collectively. So it's not just one project, it could be 4 or 5 projects that they have together, and they're going to, as a joint partnership, move more than one project down the road collectively to get a bunch of projects going as one entity. It is several projects that you can put under one umbrella, with the idea of you're going to contribute all of your specific talents to driving those specific projects that each of the two entities want to pursue. It is an ownership stake, so it's laid out very much like a formal business partnership, where there's voting rights, there's capital contributions, there are title issues, there are things that contribute to the business ends. Who's going to run finance? Are we going to open a bank account together? Are we going to hire people together to work on this slate? So when you really look to a joint venture agreement, it's partially geared to a function of the business structure of decision making. So when you have a slate deal together and you have, let's say, one romantic comedy, you have one sci-fi horror film, and you've got a monster movie, right? So each party would then be responsible for the decision making on how to get that project moving together. So if I was working with Blumhouse, say, for example, and Blumhouse and I had 3 movies together, and obviously Jason, he's one of the main guys that does horror in our business. So I would look to him to help develop the script, and I would look to him to help get talent. And then maybe my contribution is I own a finance company, so I'm going to finance all 3 projects. And how does that financing work? Do I fund $50,000 in each one of the films, or do I fund the entire slate and they all go at the same time? Do I tier them out? So these are all very high-level business venture questions that people do to collaborate on an ongoing partnership in a business venture for different sides who have different talents and can really lay out Who's going to make the decision? Is Jason going to greenlight the script, or do we get to greenlight the script together? Do I get to have a chance to fund Jason's next movie because I already funded the first 3 in my joint venture? So when we do a joint venture agreement, it is we have to lay out the expectations of what the ultimate project is going to be and what the partnership needs to get out of it, and potentially what does that mean going forward. Are we going to do 3 projects, and if we make a certain amount of money, then we're going to move on, and I get 3 more films from Jason after that. So these joint venture agreements are very common in things like first look deals. They're very common in, again, slate deals. They're common when there's 2 production companies that have an ongoing kind of genre-based business opportunities that they can merge and get into additional spinoffs. Like, for example, if one of my clients is doing a movie called Tower Heist, and it's based on the Tower Heist with Eddie Murphy, are we going to do Tower Heist 2 and 3 together? Or do we wait and see how everything kind of lays out, and then we decide to go together into a different partnership? So joint ventures are very fun to do because they're kind of these broad umbrella expectations being set, and they kind of drive a bunch of projects all at once, and you're doing business as one company together. It's different than the co-author, co-writing agreement in that it's an actual business formation relationship that has its own potential bank account. It has its own operating agreement. It has its own people. And it's I would say it's like an arm of each of the different companies merging together to do business for a specific purpose. And I think I've covered pretty much everything except for just generally saying that all of the 3 of them are sometimes overwhelming, and I know that some things can get a little bit of esoteric and complicated, but if you really look to and you sit down and you list kind of like what your wish list is out of all of the relationships with each of the people and what you foresee working on with that person, it helps to really lay out, when you see it on paper, just a list like that. What does that look to you? How does it feel to you? Do you feel like, oh, my list is 20 long and my partner's list is only like 3 things? Is that fair? Am I cool with that? Do I need to like maybe expand it or get a little bit more detailed? Or is it one of those things where it's like, well, if it's only 3, is it really worth for me to enter into this formal agreement? So with all of that, I would say, just sit back and understand it beyond the excitement of partnering with somebody. Look at it more of a practical matter. If you were married to this person, how is it going to work? Should I date them first, or do I really want to enter into this formal relationship? And if so, we're going to have to get a little uncomfortable and really push people to give a understanding of what they have expectations for themselves, what's the expectations for the other side, and vice versa. Because you might have a list that's 20 long and you see your partner's list and they might have 20 things for you. So again, it's a facilitator of communication, it's a facilitator of organization, and ultimately it's a facilitator of efficiency. So with that, I'm going to kick it back to Michael.
Awesome. Thank you so much, Tifanie. I appreciate just the care that you took in explaining these concepts to us. So I want to re-anchor the viewers that, Tifanie is an entertainment attorney. I'm seeing a lot of questions coming that are outside the scope of entertainment. So I will look to see if this is something that she can comment on, but just keep in mind that Creative Lab Hawaii currently is shepherding along creative entrepreneurs in the media, music, and fashion landscape. So with that said, the first question that popped up was, what about a simple memorandum of understanding if you don't know the future of the project? Would that be either a replacement, or potentially could that be a first step towards a collaboration agreement if people are just starting to work together and they don't quite know? Or do you still recommend that both parties sit down, outline that list of what they're delivering, what they're looking to do together, and then create that agreement?
Well, MOUs are great, especially if you're what I call dating. If you're not sure, putting anything in writing always gets people's brains moving when you see it actually on paper or on the screen, and it also helps flesh out what that person's understanding is when you actually lay it on a paper. And we do this all the time as lawyers. We take the first shot at a deal memo, and somebody comes back and says, "That's not what I meant," or "I didn't. That's not what I said," or "That's not the agreement that we did." So an MOU always is what I call the outline. It helps get the conversation started. It helps kind of outline what you think you're going to do. But in my only drawback is, especially if you really want to be formal, is it's too vague. It's going to help kind of get the person to the dinner table for the first date, but we kind of need to go further than that if you actually want to do a formal relationship.
Got it. The next question is, you mentioned divorce, quote unquote, and indemnification was one of the standard provisions outlined by Elsa Rama last week in Legal Clinic on Options. For our Q&A, do you have an example of best case, worst case scenario for indemnification, please?
Wow, indemnification, that's a big word.
That's a big word. Because it can be so many different things depending on the agreement, right?
Right, especially during the pandemic, there was a lot of that going on. Usually indemnification allows you to protect yourself for things that somebody didn't tell you about. So for example, in a co-writing agreement, usually the indemnification is important because you want to make sure that the person who you're working with is delivering whatever writing services to you on an original basis, instead of getting it from their friend next door and then just passing it over. The indemnification says things like you're going to contribute an original work, that you didn't get it from anybody else, and that to your knowledge that it's not it's not belonging to a specific new writer. It's kind of helps. It's a little protection layer so that you can move with an understanding that if you violate what you're promising me, then and we get sued, you will take the heat for it, not me, because right. So it's a good way to basically protect the promises made in the agreement in a basic way.
Got it. The next question is, I was in a joint venture agreement previously, but want to move forward in a different direction with some of the original concepts still intact. The original agreement was for a specific story series and characters. Do I need to include the other party in this new project?
Yeah, in general, when you have projects in a joint venture agreement, the key word is joint. So there, I would recommend that you formally negotiate out of whatever you need in that specific project to move it forward. I mean, we've done several ones where we negotiate a buyout, we negotiate a potential credit attribution, sometimes deferred payments, residuals, royalties, anything that would potentially help with getting the project away from that joint venture, but getting it formally out of the joint venture as far as negotiation.
Transparent way so that they don't have cause to come after you if you haven't, whether or not there is some sort of relationship still there.
Right.
Got it. So the next are outside of the scope of this conversation, but I'm going to pose them to see if you can just, yes, no, I don't have any sense of that. If you're okay with that. Cool.
Go for it.
If I use a brief story from a nonfiction book to inspire a scene in a narrative film, do I need to get permission from the author or the person telling the story in the book, or both, or no one?
Okay, that's a chain of title.
Right.
That's an underlying work. In general, I always recommend to err on the conservative side. If you're borrowing from something, we're always borrowing from something, always in our business. Inspiration is different than copying. So I would say if it's inspiration, and it's not like you're using Freddy Krueger in your deal, in your project, you may be okay. If you're taking specific characters, plot lines, storylines, arcs, those types of really things that make a story that are material to you using it for your story, I would recommend that you get permission. I know it's very hard and it's a lot. It gets sometimes tedious to get that person to say yes. But again, then if you're not going to be able to get that permission, then you need to take a little bit more of creative angle to it and steer away from it, or take it as inspiration.
Perfect. So the next one is about the art industry, and the other one is on software. So I will pose them and you let me know, or unless you're like, I have no clue about those two. So are you okay with me posing them?
We'll try them.
Okay. What are specific documents necessary for work with art institutions and independent curator gallerists? Any groups to contact for further info?
So work meaning like using the art in a project, or I don't know what the specific document for work with. Are you selling an art, right? If you could give me a little bit more specific.
Yeah, you could get a little more background. And the other thing that I was going to recommend is California Lawyers for the Arts has a big umbrella of attorneys and resources that support creative entrepreneurs across multiple platforms. So that may be also another place for you to poke around and potentially schedule an info session to provide you with additional information. But if you want to add additional info and ask back, we'll wait a couple of minutes. The other question says, please make a comment on open source software that can incorporate creative credits yet encompass spin-offs that are not understood in early stage deliverables that include public facing interactions.
Okay, so I'm going to give a very general answer because this has to do with coding and things like that.
Right.
From what I usually try to recommend is that there's certain proprietary, I guess, work that you have when you write code that you can then carve out as your own. But anything specifically unique to whatever you're writing it for, like if I was writing code for, the Hollywood sign, right? But my code kind of was very simple, but then I did a picture of the Hollywood sign and I coded that. And I did a picture of, a helicopter flying over. That's all unique to the project that would belong to the intellectual property of the person that you've done the code for. But the underlying stuff that you created as a specific kind of launching off pad for the Hollywood sign, you would be able to at least carve out as your own intellectual property. But I would recommend that you do in your services contract when you do that to make that clear.
Got it. The same person asked another question. Open sourcing is my current investigation to assist in the separation of property and public works. Okay, it goes into specifics and names companies in Hawaii, which I feel uncomfortable making public. So we're going to go ahead and skip that. Okay, so here's the same person who asked the question about art. Other than an NDA or art loan, what would be advised for exhibitions and film and performance programming?
Okay, again, I'm going to answer this in general. If you're doing an art exhibition, you want to make there's two kind of theories of thought. You want, as the artist, you want to be able to have people see it. You want people to promote it. You want people to talk about it. You want it to get noticed. However, you don't want it to then end up on a movie poster somewhere without you getting compensation for it. So usually what I recommend is that the artist has like a release that is big, signed when you walk in, that like you can film it and all that stuff and you can promote it on social media, but you can't use it for any commercially viable projects, and that everything is reserved to the artist, and that they have the right to ask for anything to be posted to be taken down.
Got it. So I want to do a couple of role plays with you before the end of the hour, just because I want to ground it based on what I know some of our fellows are dealing with. So two producers, two nascent producers decide that they want to collaborate on a project together, okay? One is a creative producer, the other one's more of a line producer, right? So one's delivering the creative work, the relationships, potentially the script. The other person is going to be delivering the relationships with crew, the ability to break down the script, and together really form the opportunity to produce the project. What would you say are the typical mistakes that individuals entering in a collaboration agreement with those kinds of skill sets make? Because again, one of the things you hinted to before is the list of things to do may be similar or the same length, but the weight of the actual ability to get something done or bring in the money maybe, is more important than the other. But how do people with these kinds of different skill sets create something that occurs as fair, right?
Right. I'd say one of the pitfalls is underestimation of effort and time.
Right.
You have the best of intentions and you feel like what you're bringing to the table is just as valuable than the other person. But sometimes it just doesn't work like that, or it just doesn't flush out like that. Or the person gets distracted by another project, because typically you have more than one co-production agreement going on. You're not just working on one. We all, especially as producers, they have 5, 6, 10, whatever projects going on. So again, underestimation of effort and time is I'd say the biggest pitfalls. But again, if you're going in knowing that, it's not about a finger pointing. It's about either it's just not working, or how do we make it work, or what do we need to do to fill the gap of the things that neither of us have been able to bring to the table because we underestimated what needed to happen to have the project get to where it needs to go.
Perfect. So the second question before we complete and I do the outro is I'm a director and I want to work with a screenwriter. I have an idea. The screenwriter has the capacity to write the screenplay, right? We create a collaboration agreement. We work on this thing for, 18 months, right? And we come to a place where the writer says, you know what, I can't give any more, right? And the director says, well, I don't think the script is ready. Right? Or it's not where I want it to be. It was my idea. Well, I put in the 18 months worth of writing and notes and doing everything else. So what is a way to structure a collaboration agreement so that I've seen these situations happen many times where the parties after a certain amount of time decide that the relationship is no longer working. How can it be dissolved in the most elegant way? And what can be included in a collaboration agreement to make that happen?
Right. So a couple of things. Going back to the stages moving forward, sometimes each phase has some type of approval language, and who gets the approval? Going back to what I said earlier, do both of them have to approve? Can one person approve and not the other? Does it have to be like a certain amount of work contributed before that person can give really approval? But generally, if I was the director and it was my idea, I would try to get myself in a position to be the driver of the car, meaning that I get to make the decision. Now, of course, the writer, because they contributed what they contributed, doesn't mean that they just, they're dumped out on the side and the car drives off. It's more like, you know what, you need to sit in the back seat because I need somebody else to sit beside me to help finish it. So the car gets bigger and fuller as you go. But if you can really get an understanding of decision-making and authority with regard to that kind of partnership, that's the best way to do it. I've seen everybody very happy-go-lucky, no, we're going to work together and we're going to decision make together. And I just say, please don't. I won't do it because somebody's going to call me and be pissed. So anyways, so I think the thing that I would definitely recommend is a way to get out of it is authority or a function to buy the person out, like a kill fee of certain amount. And then at least they know that they're getting paid.
Perfect. So again, just to reiterate, the steps could be, an outline, whether it's full blown, the first act, second act, third act, revision. So those are the kind of typical the steps that you would include. And to your point, to remember that the car can get bigger, right? That we can invite other people to the party to help make something happen, because having a piece of something continuing to have a piece of something that gets made versus a piece of nothing that gets something that does not get made is far more important for people who are starting out in the business to keep in mind, right?
Correct. I always recommend, acknowledging somebody's work, because I think that's the number one thing these people are looking for. Obviously, compensation and credit is very important, but that acknowledgement means the world. So, just keep them in the car, don't kick them out on the road. There'll be more baggage in the car as it comes, but as long as everybody is fair and runs with that contribution and those acknowledgements, then we can work everything out.
Awesome. I'm going to close out the webinar now. Thank you so much, Tifanie. It's been a great pleasure to work with you and for the time and the contribution that you've made to our community. Next Wednesday, attorney and co-director of the Creative Lab Hawaii Music Immersive, Julia Brotman, will be presenting on work for hire agreements. The webinar is scheduled for Wednesday, June 30th at 1 p.m. Hawaii. Please visit creativelab.hawaii.gov for registration information. On behalf of the State of Hawaii DVED Creative Industries Division and our co-sponsor, California Lawyers for the Arts, mahalo and have a great evening. Thank you so much, Tifanie.